Welcome back. Welcome back. I hope that that breakout room was something to get your juices flowing. And we will be jumping right into our presentation with Miss Amanda Gayle for the night.
Thank you so much. All right, let's get started, you guys.
Clap it up for the teacher.
All righty. So thank you guys so much for being here. If you are here tonight, you either have a business or you care about intellectual property. You probably see a lot of things online and want to just gain some more information about what these terms mean. And tonight we're going to make sure we cover that for you. So let's get started with what is intellectual property. So intellectual property is property that is actually created from ideas that you conceptualize in your mind. However, they actually become property and assets once you actually turn that into a business, into a real idea, until you actualize whatever the concept is. For example, intellectual property can be copyright, it can be trademark, it can be a patent, it can be trade dress. Because we are a little pressed for time tonight, we're not going to cover everything, but we're going to cover two of the most common intellectual property that comes up in everyday life. So let's start with copyright. So what is a copyright? Copyright are tangible forms of art. So think about film, TV, photography, anything that you actually can look to and say, I created this, not something like I thought of this, but I actually thought of this and I put it into action. I put it out into the world for people to actually view, to purchase, to enjoy on their own. So we have art, songs, books, photography, computer programs, TV, and film. And if anything happens with anything that you've created, what comes next? Copyright infringement. So copyright infringement is when someone actually takes what you've created and they try to use it as their own, right? Either for monetary gain or to perform it or to use it essentially without your permission. Some of the elements to copyrights are originality, creativity, and fixation. So as I said, it has to be something that is unique, that is original to you, that you've created, that is not something that's everyday out in the ordinary world. It's something that is special and unique and distinctive that you've created that actually is tangible. So that's what that fixation means that it's something not just like a concept, but something that you can touch, you can feel, you can provide to the Copyright Office and say, this is my work. So examples of infringement are copying someone else's original work. Literally, like if you wrote a book and someone copied and pasted it and decided to make copies of the book, that would be copyright infringement. I think of an example because one of my favorite shows is Girlfriends. When Maya wrote her book, oh hell yes. Oh hell yes. And she was, working hard trying to promote the book and she's getting it out there. And then Lynn, because Lynn is a moocher, right? Lynn is running around making copies at the swap meet and selling it, right? Lynn committed copyright infringement and Maya should have took care of her, but she didn't. Another example is if you're performing someone else's work. So for example, if an artist actually creates a song and then another artist actually starts to tour with that song, so they're making money off of that other person's work, that's another example of copyright infringement. So committing copyright infringement is not something that should be taken lightly. You really need to do your research before you're submitting work online, before you're doing anything where you're actually trying to make money off of something that you created. It may seem new and novel to you, but you want to make sure that you're doing a full search to make sure that no one else is actually doing it, because that takes away that originality piece, right? Committing copyright infringement can lead to fines, penalties, and yes, some people actually go to jail. Remember those movies we used to watch? I actually don't see too many of those notices anymore, but I remember back when we were a little younger, we watched Disney movies and they always had like the Copyright Act, like those notices, right? And it said you could go to jail. No, people really go to jail. So I definitely implore you to take it very seriously and make sure that you're not infringing on someone else's work. So defenses to copyright infringement. So sometimes there are limited defenses to copyright infringement. No saying that posting someone's song online and saying, I do not own the rights to this song, that is not a defense. However, if it falls under fair use, meaning that it's acceptable use to the Copyright Office, then you might be able to get away with it. So fair use includes, if you literally include like a little snippet of it, like say it's a 3-minute song, you include like 10 seconds, you might be good. Or if you're actually promoting it for education purposes to kind of advance someone's awareness about an issue or something like that, or you're providing commentary on it, you might be okay with that. Or if you're not making any money from it, right? You're literally just posting it just for fun, not for anything. It's something that is just being shared just for that, and you're not monetizing it, then you might be okay with that as well. Also, if you get a license, right? So a license means that you actually are reaching out to the person, you know that they own it, you know you don't own it, but you want to use it, maybe to make some money, right? You actually have to reach out to that person and actually obtain a license. That's important. Because not doing so could really lead to, the lawsuits and the fines and the penalties that we were just talking about.
I have a question.
Yes.
Can we ask questions during?
Of course. I want you guys, and so I'm gonna pause real quick before we go on to the next thing, because I didn't actually get to say it yet. Quick disclaimer. So just so we know, this is for informational purposes only. This does not create an attorney-client relationship with me and anyone unless you decide to do so, right? So we'll get to that at the end. But otherwise, I'm not your lawyer just by providing this information to you. Okay, good. We have to do that, just letting y'all know. And back to your question.
Official, y'all. She official.
Back to your question.
My question was to the fair use, right? So is it like could you just repeat that? Because I understand the licensing and I understand the education, but fair use. I just say it's for all fair in love and war, like.
No. So fair use would be if it is for scholarly purposes, if you change the work in any kind of way, like you make it almost something completely new by just using like a portion of it, or it's literally just like a snippet. So if it's like less than a tenth of the actual full version of whatever it is, that would be considered fair use as well.
Okay.
Hold on, I want to acknowledge Niall had a question as well. And I see Chibuzo, I'm sorry, has her hand raised.
Oh wait.
I can ask it now.
Yeah.
Okay. So I just want to make sure I was not order. So my question is pretty much, so basically with, and correct me if I'm wrong, but the originator who created the song, film, whatever we're talking about, right? They don't want to go after you. Can the state or the government or whatever go after you like they would for like criminal offenses? So like if a criminal offense was committed.
Right. Can a prosecutor, is there a copyright prosecutor? No.
Right. Okay.
So no, I think our government, they definitely have more than enough things to do, and they don't actually go after people to enforce these copyright rules unless you're flagrant or the originator has actually like made an actual claim against you, right? And
Gotcha.
the state decides to actually impose fines against you. No, they're not in the business of enforcing other people's rights. If the originator doesn't care, then that's their business. We'll talk about why that's an issue with trademarks, or hopefully we can get to it. But no, the answer is no.
And Chibuzo, you had your hand raised as well.
Thank you.
Sure.
Before my question, because it is concerning Cameron, Shadeja has a question in the comments. Yeah.
Like changing the work for entertainment purposes, like parody or satire. Yeah, that's acceptable. But it can't be anything so essentially, if you create something, if someone's created something and you take it and you try to go and make money off of it, then that's infringement. But if there's no real commercial purpose for your use, then you should be okay with that as well.
Thank you.
You're welcome. All right, let's move on to the topic everybody wants to talk about. Everybody wants to talk about Cameron. So Evelyn and Shavante were amazing enough to post about a copyright lawsuit that Cameron, Mr. Old Boy, Mr. Pink Fur, Mr. Paid in Full just got hit with last week, I believe, by a photographer, because Cameron has been using for several years this image of him from 2003 on t-shirts, on mugs, on all kinds of merchandise, likely under the assumption that, oh, this is a picture of me. So clearly I'm able to do this. Clearly I own it. Unfortunately, that's not true. So anytime a creative, a person, an author, creates something original, that belongs to them, right? The person who is actually the original creator, they have automatic copyrights to whatever it is that they've created, even if it is an image of you. So I put here that there are a couple of other issues at play, but it's likely that Cameron is actually going to be found guilty for that issue, because they've actually gave him like multiple notices. Getty Images reached out to him multiple times. They tried to contact him to let him know that he needed to stop. And that's usually what happens with any kind of infringement. You will get a notice. You get a cease and desist. It's like, hey, please don't do this. It's not real nice, like everybody, right? Hey, please don't do this. You keep doing it, the notices get a little more stern, a little nasty, and then you're getting hit with a lawsuit. The reason why they hit you with notices before they actually try to sue you is because, at least up front, until they're able to recover their legal fees, it costs money for any creative to actually go after somebody and sue them. Sure, you want to enforce your rights, but all of that costs money, right? So it's not looking good for Mr. Oh Boy, because he really was doing that. However, he may argue, and we'll have to see how it plays out, that he actually had rights of publicity, depending upon where the images were actually taken. So rights of publicity protect, and that's another kind of issue, but we're not going to get into it too much. But rights of publicity actually protect your actual likeness, right? So your image, when you go to an event, we all kind of like implicitly did it when we went to the dinner party, but I was happy for them to take my picture because I love them. When we went to the dinner party, right? Anytime you go into a venue, you're giving them the right, and you know that they're going to be capturing images. You're giving them the right to capture you, right? To use your likeness, your image, your name even, right? He may argue that he never actually signed off on that, depending upon where he was. When you're in a public place, however, some of those rights are kind of waived. So that's where the right to privacy is kind of at play too. So we'll have to wait and see how that plays out for him, but
we'll call you.
Hopefully he got it. We'll see. So if you so we'll go on to the second one. If you were following me, then you'll see that I also just posted a video about this yesterday, which is another example of copyright infringement with Lady London and Sting. So them actually being on two sides of the coins. So Lady London, this is one of my favorite little snippets. Oh, it was a song, but it's not really a song anymore. Should I be singing? Okay, I'll sing. That shorty lurking on my page. Anyway, hit the boomerang.
Yeah,
she killed that freestyle.
Listen, I've been following her since, don't you have a girlfriend? Why are you calling me? Like, I love Lady London, and she's from New York. So yes, we love her, right? And she said she just didn't expect for it to blow up this way. But at the top of the year, she was trying to get her buzz going again. She released that video, which samples What Happened to That Boy. It's a song from the Clips and Birdman. And it's a sample, and she's just rhyming over it, and she killed it. Not for nothing, I like her version better than whatever they was doing back in the day. But that's an aside. But she didn't expect for it to blow up the way it did, and it went viral, the video. But she also took it a step further, and again, back to this monetization, right? She released it on the streaming platforms. I definitely was in the gym, like shorty look at, right, like on the 12/3/30, like trying to, until one day I tried to play it and it wasn't there anymore. And then maybe like a week later, I saw her do a live where she was, I knew what happened, but I saw her do a live where she was explaining that she's trying to work it out, which means she's trying to find the coins and also see if they would even grant it. to her at that point if they would even allow her to use it. So basically, by using the song and putting it on streaming, she kind of definitely overstepped, right? And she needed a license to be able to use it that way, because they're not going to let her make money off of it using their original works, right? So it's not there anymore. Hopefully she's able to sort that out. I also threw Sting in there because recently, it's an old interview because Angela Yee is there. It's an old interview that's recirculating with Sting where he's explaining that Diddy did the same thing, right? Where he released I'll Be Missing You, which is a tribute to Biggie, without first reaching out to Sting. And Sting said, no, where's my money? So the actual number of like what he owes, what he's paying Sting daily, because they're kind of facetious about that, like it's 2,000, it's 5,000. We're unclear about that, but between them, Sting is definitely getting a check frequently, right? Like from Diddy, because Diddy released that song without his permission. And unfortunately, on the back end, sometimes they're going to be less forgiving. The price is definitely going to go up, right? After they see how popular it is, how much people like it, they're definitely going to raise whatever the cost is going to be. So you definitely want to avoid that. If you're an artist, if you know any artists, make sure they're getting the licenses before they're releasing their songs. It's kind of tricky to get licenses, so you definitely want to reach out to an attorney to do it. I always recommend me, but you do what you want to do. Alrighty, so that is copyright. Before I move on, what happened here? Okay, before I move on, any questions about copyright before we go on to trademarks?
So going back to the Cameron example, it's interesting because to my understanding at a high level, it's three people involved. It's Cameron, the artist. It's D. Jamila Cochran, the photographer who took the picture of him, and it's Getty Images. So why I say it's interesting is because I don't know if it was Getty that like did the cease and desist first, and then D. Jamila did like a countersuit. And now I'm wondering who actually owns the photo. Is it Getty Images or is it the actual photographer that Getty Images contracted to take the photo?
So that's really that really is determined by whatever the work for hire, the assignment agreement between Getty and Jamila, right? About who actually owns it. It's likely that they paid her, but she still may retain some rights. We don't know what their agreement says.
Okay, I didn't know if that was like talked about or clarified or not, but I know a bunch of us were talking at length about this conversation, and then like how you said, Cameron it didn't, I guess, explicitly consent, but it was in a public space, the Grammys, I believe. So it's like it's already kind of like you waive your rights. So that was like another part of it as well.
Yeah, he may or may not have. The court is ultimately going to decide, but those are all of the issues at play for sure.
So I had a question in the chat.
Yeah, let's see.
Patrice asks, what happens if we do photo shoots for our website? Should we ask for rights from the photographer?
So again, I don't represent anybody here until you decide that I should. But I'll give y'all a gem because y'all took your time out to be here tonight. I always encourage my clients to get a work for hire done for them when they're hiring any creatives, which is essentially having the creative assign the rights that they naturally possess once they create whatever the work is to you, right? So essentially that's what's going to give you the opportunity to know they're not going to be able to sell it to Getty Images, right? They're going to have to give it to you and you have it and that's it. And you can take that and do whatever you decide to do with it from there. But yes, you should definitely give them that agreement before you have a photo shoot. And if they don't want to sign it, then maybe they're not right for you. And always, if anyone is like leery to sign a contract, reconsider whatever relationship you have with them.
So Amanda, if I could ask a question, this is Tony, the attorney. How are you?
Good.
So I had someone design a logo for me recently.
Yeah.
How do I go about that? Like I'm paying him for it, so it's mine, but he designed it. So is that a situation where I need him to sign one of those things we just talked about?
So I would love to talk to you more about that. Let's
Okay, I'll reach
let's
out
put
to you
that,
outside then.
yeah, let's put a pin in it for a second, but that's a good question. All right.
Okay.
So let's move on to trademarks because I wanna make sure I'm respecting the time here. And then we have time for more questions at the end too. So let's talk about trademarks. So trademarks, we just clarified that copyrights are for original forms of art. They're tangible forms of art that you actually can register. They're important. Someone mentioned to me that they think that there's like a hierarchy for intellectual property, and there isn't. They just operate differently. Trademarks are very, 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 very important because they actually let people know this is how I want to be viewed out in public, out in the commercial marketplace, right? This is your commercial impression to consumers, right? It's letting them know, hey, this is the name of my business. So the name of my business is Gayle Law Firm PLLC. Trust me, I wish I could have made it something flyer, but the New York has very strict rules on what we can name our businesses, but that would be my service mark, my service trademark, right? Gayle Law Firm PLLC, right? Also, if you've seen, it's on the first page of this PowerPoint, the logo for my business. That is also a part of my trademark, right? So one is a word mark and one is a design mark. They're equally important, but they notify consumers, hey, this is how I want to be identified, right? And this is how you should distinguish my business from other businesses. Okay, so a trademark can be a word, a logo, a symbol, a phrase, even a color. So Tiffany's, you know, Tiffany blue, that's why we call it that, right? Wait, it's like this right here. That is Tiffany's trademark because we see that color and we know that's Tiffany blue, right? So all of these things can be used to identify a business out in the world. So almost all goods and services can be protected by a trademark, but not every word, logo, or symbol is eligible for trademark registration. What that means is there are 45 classes of goods and services where you actually can protect your work. However, people come up with all different things that they believe are their trademarks, but there are strict guidelines to what actually can be registered. Okay, so why should you trademark? So, like I said, you should trademark because it lets people know this is actually how my brand should be identified. But it also protects your brand, right? It protects your brand from infringement, like we said. So we were talking about copyright infringement, but trademark infringement happens as well, right? If there is another business using your business name, right? Something that you created, whether intentionally or unintentionally, there is a possibility that consumers won't know who is who. And let's say they do something similar to you, somebody sees them, they think it's you, they wanted to find you, they think they found you, and that person gets the business, right? So that's one of the reasons that you want to trademark your business. It also increases your credibility, right? So it's more than just having that little R behind your name. That's the R registration, not the TM. A TM actually notifies people that you are using it as a trademark, but it doesn't indicate registration, right? That R is when you've actually received official registration. Don't use that without getting it because that's actually fraud. And if you ever decide that you want to go the proper route and actually register it, the USPTO could already have that information and deny you. It also increases your business valuation. So when we're talking about, oh, I want to scale my business, I want my business to be booming, I want investors, I want all this stuff, I want angels and series A and B and C. Oh, wonderful. When these investors are evaluating your business, they're also looking at your intellectual property portfolio and they're considering if you own your marks, if you own your copyrights, if you own your trademarks, if you own anything else that's associated with the business. That's important, so important. I'm saying a lot tonight, but that's one of the things that you should be like writing down. Because if you wait until your business gets big for you to actually go and trademark it, oftentimes these big brands, they say, oh, this isn't registered yet. Well, that's going to be the first thing we do. And whose name do you think they're going to put it in? Yours? No, they're going to put it in their name, right? So everything that falls from the rights connected to that mark are going to go to them, right? There are going to be things that you could potentially still negotiate, but you want to make sure that you go to them and you're like, well, I already own this. So now show me why I should share that with you. Okay. Also creates licensing revenue. So we kind of covered that already, right? So we're thinking, so Sting, that's why Sting just, have you heard a Sting song lately? He don't need to make no songs. He living off of Diddy, right? It creates licensing revenue, right? It's another avenue for you to make more money, because once you own it and you build it up to where it's something that people are seeking it and like it's highly sought after, you've created another opportunity to make more money. So those are all the reasons why you should trademark. So let's talk about trademark types. So remember I was saying that not every mark is eligible for registration. So there are multiple different types of marks, and I'll just go through these briefly. So fanciful marks are going to be marks that you have completely created out of thin air. So that's going to be Pepsi, that's going to be like Xerox, things like that, which is literally just like a mashup of letters that you pushed together and created a brand name, right? Never existed before, completely distinctive, completely unique. That is what the USPTO, which is the U.S. Patent and Trademark Office, asks for when you're coming up with these trademarks, right? Something that is unique. And it's, again, because I said that it helps you to distinguish from other brands, that's what you want it to be, something that is unique. So it decreases the likelihood that anybody else would have your brand. So arbitrary are marks like Apple. So a lot of us are probably on like nice fancy little MacBooks now. So Apple obviously is a food. So that's the ordinary meaning, but they decided to actually assign it to tech products, right? So that's unordinary, right? That is out of the ordinary. That is unexpected. So because it's arbitrary, it's also unique in that way because you don't see it coming. So suggestive, I'll just go Netflix. So Netflix, they create TV, film, it's streamed through the internet, Netflix, right? So it's not direct, but it's suggesting to you as the consumer, hey, this is what we do, without like slapping you in the face with it. Brands that slap you in the face with it are considered descriptive. So the top three that we were talking about, very good names in terms of trademark registration eligibility. But the next two that we're going to cover are not as good, right? So descriptive would be like American Airlines. They fly within America. Airplanes, right? It's too on the nose. It's too in your face. It's literally saying, this is what we are. There's a company called Good Pillow. Okay. There's nothing unique about that. There's nothing distinctive about that. Those are not good marks for trademarks. So again, when we're talking about eligibility, those are concerning. Then we have like generic, common. So Jello started off as a unique trademark, right? It is now the generic form term for gelatin, right? And we can talk about how a brand becomes generic, but essentially, if too many people use it, you don't stop them from using it for the general term for whatever that item is, it becomes generic. Common marks are also discouraged. Common marks would be marks such as a couple years ago, LeBron tried to register Taco Tuesday. They said, no, go away. Because obviously people have been hosting Taco Tuesdays long before King James, and it was denied for that reason. Any questions before I keep going? I can go forever.
The dinner party NYC, are we descriptive or suggestive or what?
You better ask the good questions.
Come on, somebody.
It's a good question. If we're thinking about the dinner party in the way that you guys just hosted that event, that was a beautiful dinner party, then yes, descriptive. But if we're thinking about the dinner party in the way that we're having it now, where it is, and let's think like creatively, right? Where people have the opportunity to feast, so to speak, right? On resources, on information, and get education, right? About topics, then no, it's suggestive. It's maybe arbitrary, right?
Nice. Thank
Yeah,
you.
you're welcome. It depends on how we use it. So we can definitely talk more about it. I wouldn't try to register it for we wouldn't register for dinner parties. We could register for events, but we'll talk offline.
Question about that, because like you know, like when you're doing like starting your own business and you have like a DBA or you start your LLC, and some people have gone on to like trademark their name. What I'm trying to rectify like the difference between like what my business name is, right, versus like and doing business as versus how a trademark is any like the difference between the name versus the trademark.
So your business name doesn't have to be your trademark. Your trademark is how people see your business. So if the DBA is how people see your business, then that would be the mark.
Okay.
Okay. Let's move on. So trademark issues. One of the biggest issues with trademarks are likelihood of confusion. Happens all the time, every day. If there is a business that has a similar name to your business, are also doing the same work that you're doing, providing the same goods, and you try to register it, you're gonna get an office action. And it's up to you and the attorney you hire, because hopefully you hire an attorney, how you want to resolve that, right? I don't implore people, if anyone here has ever tried to respond to an office action on their own, I don't suggest you do. I've seen lots of responses written by people who don't do that work every day. Listen, I don't fix computers. I don't try to fix computers. I don't bake cakes, not all the time, not professionally anyway, so I don't. Leave the things that the professionals do to the professionals, because you want to make sure you're preserving your time, your energy, your resources, your money, and it's getting done correctly, because there's definitely a science to it. If you want to talk about it, we'll talk about it, but I definitely don't suggest that. So likelihood of confusion is one of the major issues with some trademark applications. Group trademarks are also a very, very big hot topic. So I recently saw a video of 112 or 56, as you would call them, because it was only 2 members of 112 performing. And the way
Did you say 56?
Yeah.
I'm done.
I'm on mute, but you have me over here just like
dying right now.
Because it's literally Slim and like, I think it's Deron, the one we never paid attention to. It's Deron, and then it's 2 guys who just dance.
I only know Slim's name. I
don't know.
That's what I'm saying. Like, you in the
Q
lead.
was fine. So I remember Q. Q ain't there no more. And I don't remember who the other one was. It was Deron. It was another one. Anyway, it's 2 of them now. It's 56. So, but Slim is able to perform because Slim actually owns the trademark. What happens oftentimes with a lot of these groups, and group trademarks operate outside they operate outside of the entertainment world. I'm just using that as an example, because obviously a lot of people form businesses as collectives, and that's amazing. But when I represent people, everybody's name is listed on the application. I don't care what the issue is, who's not available, why they can't. Oh, I'll sign for them. No, everybody signs, because me personally, I don't like to be caught up in any nonsense. Like, I don't want those things to come back later. And I've seen so many things go awry with just, group situations. So we always encourage and require, really, from the intake to the end to the filing, that all group members are included on all correspondence, all applications.
You heard that, Shavante?
Y'all good. Everybody signs the application on my end. I'm talking couples. Listen, it's my son and me building business. Great. Everybody signing this application. I don't want to be. I just don't. But group trademark. So that's how he's able to go on. New Edition had the same issue. Where Ralph and Johnny, I think, they found out that it wasn't. New Edition performed for years, you guys, years, and never trademarked New Edition. Isn't that crazy? It's crazy. Up until a couple of years ago, if you remember, when they started performing as like RBBM or whatever weirdness it was, It's not Belle Biv DeVoe, but like something weird that they came up with that nobody recognized, but we just wanted to hear them do, you know, the da-da-da. I like that song.
It's the culture representation for me.
I'm a fan. So yeah, so luckily they've all been able to put that aside, and now they all own the rights to New Edition, all 6 of them, including Johnny. But that's why it's really important to get those things taken care of as early as possible. I posted recently also about Ronald Isley, his brother Rudolph, because it was 3 of them, and one of them died, RIP. But Ronald, Mr. Big, he looking real shady right now because he actually filed to register the Isley brothers without Rudolph, and now Rudolph is seeking his 50% because I don't know what Mr. Big was thinking, but we'll see that play out in court as well. So group trademarks are other issues that happen with trademarks, but these issues are very nuanced and really, really, really important. Make sure that you have representation when you're filing. Okay, any questions before we have some fun? It's more fun.
Like, how long does it really take to complete the process, like from start to end? Like, what would be the average timeline of when you start your trademark to like how long it could go?
Great question. So it used to be anywhere from 3 to 6 months. You would hear a response. We filed the application, and then you hear right back from the USPTO within a few months. They blame COVID. I still wear a mask, so I still believe that COVID exists. People have germs. Yes. But I don't know how you're still blaming COVID in 2023. Like, people go back to work, people work remotely, things get filed. I don't understand. There are impacts to the workforce as a result of COVID. We understand that, but their timelines are just crazy. So an application now can take anywhere from, I would say 6 months, but that's not true. So 9 months to really like a year to complete the process. But it also is dependent upon what happens within the application. If the application smooth sails, I would say like a solid 8 months. But if you get an office action, even for anything minor, it might add a little bit more time.
Okay, thank you.
You're welcome. All right, let's have some fun. So remember we talked about the different categories of trademarks. Let's do a cute little quiz. So we had fanciful, we had arbitrary, and we had suggestive, we had descriptive, and we had generic, and we had common. So now let's look at these examples. So number 1 is Jamie and Mike are launching a gardening company. They keep hearing people say, we understood the assignment. Can they name the gardening company? We understood the assignment. Take 2 minutes, answer A or B in the chat, and we'll come back. Think about it. A. Okay, Kavan says A. What does everyone else say?
I say no.
B.
Have a lot of B's. We have some common similar to the LeBron Taco Tuesday. But Taco Tuesday is a little bit more broad. We understood the assignment. You know who said that.
But that don't got nothing to do with gardening though.
Good question. Good point. You know, we work for USPTO too, right? And they will definitely suggest something and be like, nope, heard it, know it. I'll be like, how do you know this? How?
Because you know how they like to.
And are Jamie and Mike part of the non-pigment persuasion?
We work there too. I don't know.
She said they black. She said, are they black? That's what she said.
Okay, so the answers that said no, it's a common phrase are correct. I believe that we understood the assignment because if they've said it on Good Morning America or something, it's common. It's been done, and you're likely going to get an office action that says that's a common phrase and it can't be registered. So they can't go with that. Let's move on to number 2. So they think green plants is a straightforward way to appeal to customers. Will they be able to register green plants for their gardening company? No, no, no.
That's all right. I'd rather be wrong and strong than not participate at all.
Oh, I
don't
didn't answer
care.
yet. I'm just reading. I'm reading. No answer yet. Let's see. I think yes. No, LOL. No, no-ish.
LOL is the safest answer.
LOL is a good answer. Just put a haha. Okay, so the answer is no, that is descriptive. So green plants literally describes what they do, right? So green plants for a gardening company would be considered descriptive and is likely going to be rejected. Let's move on to our last question, which says Jamie and Mike are intrigued by arbitrary names. Mike comes up with lettuce for their gardening company. Jamie hates it and says it isn't arbitrary. Mike wants to name it green tea. Who's right? Mike is correct. Name it green tea. That's why I like that too.
Mike and Jamie already not getting along at the name. Like, let's talk about that.
You gotta work through these things, right? Like, you gotta know. Honestly, before you launch the business, I definitely tell people that we should be talking trademarks before we got inventory, before we got a website, before we got all of these things, because the first thing you need to do is make sure that the name is available. So if Mike and Jamie ain't getting along at this part, then it might be a telltale sign and they might need to, or maybe they can work it out.
Maybe I missed this, but is there a way we can check if a name's available beforehand? Is there like a website to do it outside of just like, what state you're in?
Good question. I'll answer that after the quiz.
Okay, perfect.
So let's put a pin in that. Tess, yes, lettuce is too generic. Okay, so lettuce is actually not generic. I know they are a gardening company, right? But lettuce is something that they grow, but it really is suggestive, right? It's suggestive, it's arbitrary, because you don't necessarily think that you would apply lettuce, which is a vegetable, to a gardening company, right? So that's actually a good name. Green tea is better. Green tea is definitely better, but they're both right, actually. Those are good names.
So that was a trick question. Hi.
A little bit. Just making sure everybody's paying attention.
We love it.
All righty.